Good afternoon. Thank you for joining today's webinar, E-commerce ADA Strategies for 2021. We will be getting started in just a couple minutes. We're going to give a couple more minutes for people to join. But if you registered for E-commerce ADA Strategies for 2021, you are in the right place. Hi, good afternoon. This is Bethany Servin. I am the Marketing Director here at UsableNet. Thank you for joining today. Our webinar is E-commerce ADA Strategies for 2021. We are about a minute past the hour, so I'm just going to go ahead and get us started with some housekeeping items. I know people are still joining, and I want to thank everyone for reserving this time today for our webinar. And again, that title is E-commerce ADA Strategies for 2021. We are recording today's webinar, and an email with a link to that recording will be sent to you early next week. We also have live captions on today's webinar. So if you need live captions, you'll want to go ahead and enable them in Zoom. The slides from this webinar will also be made available after the webinar. Our speakers today are Dianna McCarthy, partner at Winget, Spadafora, and Schwartzberg. Dianna practices out of the New York and New Jersey offices. Her practice today focuses on media tech claims, incident response, and counseling clients on cyber security and employment issues. Dianna is also a litigator and defends matters including the ADA, privacy litigation, employment law, commercial litigation, and professional liability. We also have on the line Heidi Gootnick, an associate with Winget, Spadafora, and Schwartzberg. Her practice focuses primarily on technology and cyber disputes, as well as the defense of professionals, directors, officers, and corporations against a wide variety of claims, including but not limited to malpractice, discrimination, and employment disputes. So we are very lucky and excited to have these guest presenters today. I do want to confirm that all attendees are in listen-only mode, but if you have questions for our presenters, we welcome you to send those in. Please use the Q&A box for those. And we've reserved about 15 minutes at the end of the call to answer those questions. So we're excited to have these attorneys on to answer your questions. And then finally, we have UsableNet's own Jason Taylor, who is our Chief Innovation Strategist and Advisor to the UsableNet CEO with 20 years of experience in usability and accessibility. And it's my pleasure to hand the presentation over to you, Jason.
Thanks, Bethany. And again, thanks everybody for taking some time out. I'm going to quickly cover the agenda so you get a feel for what we're going to cover today. Essentially, we want to give you as much practical advice at the end in terms of, I would say, like 3 broad areas, where lawsuits are coming from, how they're structured, and what your initial options are with regard to if you receive a legal action We want to start by covering the sort of the business case for ADA compliance. It's not only a legal minimal risk point of view, but we are here to really take you through the sort of the detail and on the ground. So I'm really happy that Dianna and Heidi are here. They're both practicing in the hottest regional area for ADA lawsuits right now, which is New York. So they've got a lot of practical experience helping clients defend and take those first steps when they do receive a legal action. We're going to talk a little bit about the effect of the DOJ. We're going to look at the actual trends we've seen so far this year in 2020 in ADA lawsuits against websites and apps, what to expect in a claim, what your first actions could be, options, what your legal defense options are. And probably at the end, what we want to do is sort of give you a short list of what you could immediately do right now to put yourself in a better place to firstly support people from the disability community, and secondly, reduce your risk of receiving a legal claim. Bethany, if you could just progress one slide. So the business case, I think for me, is really important to understand. First, this is about supporting a community. That community is very large. Over 1 billion people worldwide have some form of disability. If you then sort of add in the aging population, accessibility and web accessibility guidelines on websites and apps not only help the disability community, they help people who have fading eyesight and need bigger buttons, and so it can make sure that your website's working better for the aging population. The other factor is that if you make your website more accessible, you're probably going to make it easier, simpler, and easier to use. I can just point to some of the most accessible websites out there today and apps out there today are people like Amazon, and that is the best experience for everybody else. So the fundamental sort of guidelines to make things work for someone who's disabled will make that sort of website or app easier to use for everybody. So essentially, from a business perspective, it has a strong ROI to follow accessibility. But let's talk about sort of why we're here probably today. And if you can move on one slide. It's not something that's just happened. And I think it's an important point, and I'm going to get Dianna and Heidi to talk a little bit about the history of how the DOJ has affected this sort of space and why lawsuits are sort of structured in a certain way, worded in a certain way. And a lot of that goes back to how the DOJ has been an active voice in confirming their view that websites and apps are subject to the ADA. And just for those that maybe can't see this slide, this data that we've collected essentially is twofold. One is the top line indicates how many lawsuits the DOJ from the year 2000 entered in on the plaintiff side to argue that the ADA websites and apps were subject to the ADA, and essentially brought large companies to settle in a certain way on committing to making sure their websites and apps were accessible. And then in sort of around 2017, that effort ended, and essentially what you've seen is an explosion of the private plaintiff sector taking on the what I might class as you could be kind and say it's a proactive advocacy, or maybe Dianna and Heidi, you could give some background of why that sort of 2017 date point changed a lot in this particular space.
Sure, yeah, absolutely. Thank you so much, Jason and Bethany. So I prefer to start back in 2000. That's when the DOJ started looking at these issues. In 2008, that's when we found a standard called WCAG 2.0, which is a worldwide initiative to make the use of a website more accessible for not only seeing impaired, but also mobility impaired people. There's a movement for that. So in 2015, December of 2015, a group of 9 senators wrote to President Obama and said, please jump on, help us get some guidance here from DOJ. We don't really know how to advise our constituents who have businesses in terms of how to get themselves to be up to date on their websites. And in about 2008, the Department of Justice also endorsed the WCAG standard. So after the December 2015 letter from the senators went out, the plaintiffs' bar started to explode, and they started doing demand letters. And they didn't identify any plaintiffs in those demand letters. They would just send them on businesses and retailers and say, you have to become WCAG 2.0 compliant, or we're going to sue you with an unnamed plaintiff. And they were using their own vendors to do monitoring going forward. So a lot of the problem right now is the information that we are getting from the Department of Justice is that they were looking at doing WCAG 2.0 as the standard, but they were going to phase it in over a 3-year period, which would give businesses time to create a budget and to refocus on their websites again. But then with the lawsuits, that started to not happen, and the Department of Justice they backed out around 2018 when the Trump administration decided not to move forward with the initiatives. But the DOJ had been promising from 2010, 2011, 2014, 2015 that it was going to provide guidance, and it didn't. So this has been going on for quite some time, the lack of real guidance from the federal government. So if we want to go to the next slide. So the question is, do websites fall under the ADA? And the ADA was a bipartisan legislation that came about in 1992. In 1992, there wasn't a whole lot of information about websites, and no one really anticipated that what just happened today was going to happen. So that was omitted from the ADA. Congress had another chance in 2008 to revisit it, and they chose not to revisit websites then. And so as litigation goes, and in around 2015, Netflix had a show called Daredevil, and its star was a seeing impaired lawyer. And so a lot of the seeing impaired community was very, very excited to be able to, watch this superstar, this superhero in a movie and shows and whatnot. And unfortunately, Netflix did not make that accessible. And so that was one of the first lawsuits that we saw where a circuit decided to go along the declaring that websites it should be ADA compliant. So if we want to go to the next slide. So this is what the ADA requires. It requires that any place of public accommodation by any person who owns, leases, or leases to, or operates a place of public accommodation should be ADA compliant. And so then the leap started to occur that is not just like for the brick and mortar facility, it also is for the internet. And so that's the background history on the ADA. And we can go to the next slide. So then we have had a circuit split around the country. Some courts have refused to extend the ADA to cover brick and mortar structures, and others have said that it applies no matter what. And then the U.S. District Court of Massachusetts was the ringleader here with the Netflix case, and that is where we really that takes us full circle here. So Heidi, did the Supreme Court ever have a chance to speak up about this, and what did they do?
Thanks, Diana. They did, and they left us hanging. So in the Domino's Pizza case, there was a plaintiff who alleged that the Domino's website and app did not allow him to order a pizza. He sued under the ADA. Domino's argued that the ADA did not apply to the website and its app. Got all the way up to the Supreme Court, and the Supreme Court declined to hear Domino's appeal. So there is no confirmation from the Supreme Court about this, but I think that pretty much all of the circuit courts now are finding that websites and apps can be a place of public accommodation.
I would agree with that. Yeah, and I think one of the in addition to the Netflix case, there was also a big case out of the Eastern District of New York in 2017. It was the Andrews versus Blick matter. I actually went, Judge Weinstein actually had a science day in his court, and I thought, well, I'd really like to go see how it's done to make websites ADA compliant. So I went to that in person. I didn't learn a whole lot, unfortunately, because we spent a lot of time just basically navigating the Blick website. Didn't get into the nitty gritty of how to code. So that's when I really started personally becoming super interested in this area, because I thought it was just so amazing that this could happen, and it could be relatively, you know, you could actually do this to help the seeing impaired people. So next slide, please. So Jason, I think you wanted to.
Yeah, I can take back over on the
Okay,
on
sure.
the trends. So, you know, what Dianna and Heidi have sort of painted the picture is that the DOJ essentially has, you know, spent 20 years sort of establishing that they think that websites and apps are subject to the ADA, and then early lawsuits where, you know, a company sort of said, hey, we don't think we are. Essentially, most circuits have decided that yes, you're subject to ADA, although they haven't been very clear on what that means. What that has left is a very nice sort of gray area for plaintiff firms to take advantage of. So I think that the key thing for e-commerce companies to understand is that they're right up there in terms of the top target of these plaintiff firms. So when I talk about top target, last week there was 100 lawsuits, so about 2 an hour, and 76% of those on average are retail-based websites or apps. So retail really is up there as the first target. So why is that? I think the first thing you understand why the top target is that retail sites are very easy to visit. And I think actually maybe I could get Dianna and Heidi to give me an idea of, or maybe just confirm, how are these sort of plaintiff sort of demand letters and lawsuits put together? Because I think that the first thing to realize is it's not, you know, last week was 100 lawsuits. It wasn't 100 individuals that are over the last 6 months are frustrated with using a retail site and went out and got an individual lawyer and asked them to help them sue a company. It's more of a sort of a process and a business case where out of those 100 lawsuits, 80% of them are filed by only 10 law firms. So maybe Dianna and Heidi, you give us your sort of insight of how you think these sort of quote unquote cases become filed. Like how do they work as an organization to create so many lawsuits so quickly?
Sure, Jason, I'll start, and then Heidi will jump in, because I started handling these all by myself when the demand letters would come out with an unknown plaintiff, and it was primarily out of one law firm in Pennsylvania. And they would not name a plaintiff, and there was one judge in Pennsylvania who said that was okay, you could continue that way. And then they tried to do it in Oklahoma, and the judge out there said, absolutely not, you're practicing law without a license in Oklahoma. You must identify a plaintiff. So those demand letters morphed into lawsuits. So what we are seeing currently, not only in the retail space, but also in the hotel space on websites, are serial plaintiffs. And the serial plaintiff is exploding, generally with the same law firm. But we recently had a few new less experienced attorneys jumping into this space too, which Heidi has had some intimate familiarity with those folks. So Heidi, if you want to say what you've been experiencing.
Sure. So like Dianna said, we're seeing a lot of serial plaintiffs, a lot of recycling the same boilerplate complaint, you know, just alleging the same thing, but then subbing in a different retailer or, you know, whatever the industry is, and then subbing in whatever the product is that the plaintiff alleges they were trying to view and purchase on the website. So we found that, you know, none of these new attorneys that are coming onto the scene, you know, will say things like, oh, well, your client's a large company, they can afford to settle this. So we'll get that when we get settlement demands. But a lot of these plaintiff's attorneys will just come to you with a settlement demand immediately after they file the complaint. And And we note that not a lot of the money goes to the plaintiff themselves in these settlement demands. A lot of it goes directly to the lawyers. So as Jason was saying, this is a business. I don't know if you have anything to add there.
Well, yeah, and just to sort of give you an idea why I feel that retailers are sort of high on that list. So, you know, if you're a plaintiff firm and you're thinking about, hey, we really want to go out there and find companies that aren't doing a great job on accessibility, or can be claimed to not be doing a great job on accessibility. We want to find lots of them quickly. You know, retail sites, there's lots of them to start with. They're easy to visit. It's easy to give the plaintiff, in this case, it might be a blind person who's, you know, an individual that's listed on, you know, 10 lawsuits a week, where that plaintiff, quote unquote, has gone and visited a retail site, tried to do the same things that are listed in the claim, you know, visit a PLP page, add a product to cart, try to proceed, to sort of document easily a similar type of issue on every single site that they sue. So, you know, you've got the fact that e-commerce sites are complex, so it's very hard to keep up with standards like the WCAG. They're dynamic in nature, they change a lot, so it's easy to assume that they will have problems, which is why, you know, a boilerplate that says, you know, there's issues with forms, with headers, with links, with alt tags are probably correct, although they haven't actually really gone out and decided that these are real barriers to equality. They're just used as a sort of a way of sort of balancing the scale towards the plaintiff. And the other thing is that, you know, retailers generally sort of understand the ADA, especially if they've got physical space. They're used to these types of lawsuits or having to apply to adhere to the ADA in their physical spaces. So it's not an unusual concept for them. And they also have lots of websites and apps. So if you're looking for multiple ways to sue someone, you go after companies that have got multiple things to sue. So that's typically why we see that the retail is sort of top targeted. Bethany, if you want to move.
Yeah, we have a bit.
Sorry.
Oh, actually,
yeah,
I just have one more thing to add to that same topic. We had a repeat client who was one of the first ones we had back in around 2016. And at that time, they had on staff coders who were actually, who were into and were aware of making their website accessible. And then, unfortunately, they fell in some hard times and weren't able to keep their website up to date as they were getting new products in. And unfortunately, they were sued again. And so we've been defending them in that matter. And they have actually retained a vendor going forward to help them continue with that process. But I was sad to hear that this happened to this company, because we really tried to keep it so they would not be sued again, but unfortunately they were. So that is one of the problems that we're seeing, that just because you're sued once doesn't mean you won't be sued again. And it could be from any number of serial plaintiffs that are out there. And that's all I wanted to add there, Jason.
Yeah, no, and Dan, maybe you could take us through this slide, because it talks about like what you typically see in a claim. And I do this on purpose in terms of this is sort of content. If you understand what's in a claim and how these plaintiff firms work, I think there's also that also creates a short-term roadmap that we can talk about what you should potentially do to avoid these claims. So that's why it's important to understand sort of what's in these claims. So maybe you could just take us through this slide, Dan or Heidi, on sort of what you typically see in a claim and how it's sort of constructed. You mentioned a couple of things around sort of boilerplate, but I think it's worth sort of just re-establishing how you think these sort of claims are put together.
Sure, Diana, do you want me to?
First, I can, well, Heidi, I'll just start off with the UNRRA, and then you can go to the other areas if that works. So I recently had a case in California under its UNRRA statute, which is a state statute, and they've been bringing a ton of claims in the state court out in California. We also have a California office, but I've been the one handling most of these types of claims out there from a partner level. And under UNRRA, there's actually statutory damages that can be awarded, and that's $4,000 for each incident. So there was concern out there that was going to be every time a plaintiff visited the website, that's going to be $4,000 for every single time. Luckily, there was a recent decision that limited to just the one time its plaintiff was harmed. but that there's been some effort to try to apply that state court law in other jurisdictions. It's not gained any traction yet, but the plaintiff's bar is really, really trying to do that. So they can get avail themselves of 3 times actual damages, but no less than 4,000 statutory damages. So that is a very real legislation to be aware of. And again, it does not specifically say your website has to be WCAG 2.0 or WCAG 2.1 or WCAG 2.2 compliant. It just has been interpreted to apply to websites. And that was what I wanted to add to that, Heidi.
Sure. So, and again, we see these suits brought by a vision impaired individual. They usually purport to bring the suit on behalf of themselves as well as a proposed class, which sometimes gets a little hairy when you're crafting a settlement agreement, because if you want to settle on behalf of the proposed class, you know, the court needs to approve it. If the judge decides you want to notify everyone in the class, that can get expensive. So a lot of the times you're only going to settle on behalf of that individual plaintiff. And we'll get to this when we discuss settlement agreements, but there is some language you can put in there to try to say that you purport to make this agreement on behalf of all others similarly situated. And a lot of times, since these are boilerplate complaints, the complaint is just going to throw in every single WCAG violation they can think of, even if that website does not have those issues. And some plaintiffs firms do run a scan of the website, others don't, and they just throw the claims in. Jason, do you want me to discuss some of the things that they're alleging are problematic with the website, like alt text and things like that?
Yeah, I think it's useful to understand that you know, the sort of the detail that they use or don't use, sort of the broad brush approach that they use, because I think again that helps someone think, well, how do I prioritize what work we should do on our website? Do you mean?
Sure. So one of the biggest things we see is that a claim that there's a lack of alt text, which is where a sighted individual would see an image on your website, but a visually impaired person using a screen reader would need the screen reader to read a description of it. So if you lack alt text, a visually impaired person cannot browse your website and see your product. Other things involve forms. They may not be able to fill them out. They may not be able to properly do the CAPTCHA code to prove that they're not a robot. If you have an image with a bunch of different hotspots for links, so for example, if your website now has, you know, Black Friday sale, shop now, and then a separate thing you click on for shop women, a separate thing you click on to shop men, a separate thing shop home. If there's no alt text link for that, then the visually impaired person is not going to be able to click on those individual links in one image. Drop-down menus is a huge issue. If those are not compliant, then the person cannot pick quantity, color, warranties, things like that. And also even something as simple as requiring that a mouse be used to navigate your website. A lot of times, visually impaired people need a keyboard to access the website. So all of these things make it very hard or impossible for a visually impaired person to explore the website. And so these are sort of all the things that are thrown into the complaint. Sometimes they're true, sometimes they're not. But again, these plaintiffs' websites are often quantity over quality. So chances are at least one of those, there's an issue with it on your website.
Yeah, I think that's really important for people to grasp, which is, you know, there is sort of this nature of I think you talked about template or cookie cutter and stuff like that. There's definitely a nature to all of these claims. What they go after is what they perceive are common issues that a website will have, and you know, they pretty much know that if they claim that against 100 websites, 98 of them will have some of those issues. And essentially, then now you're in a position where you have to claim that those issues aren't big enough to be discriminatory. Those issues aren't big enough to block someone from using the site and executing what they want to do, which becomes costly in terms of trying to argue. So this is why they put all of these elements in, but again, to sort of tip the scales towards their argument that work has not been done to support people who are disabled. Maybe.
And I do have some. Oh, sorry, Jason.
No, Dan.
I did want to jump in with.
If you had anything to close out on that one.
Yeah, I did want to add some good news that I recently had out of Florida for a case that we were handling for a retailer. The court there actually sent out preliminary discovery requirements for the plaintiff to actually prove why they could not, or allege why they could not access the website and make their purchases through the website. So that was finally the judge there was putting some burden on the plaintiff from the very beginning to establish that he had a legitimate lawsuit rather than just assuming you're just going to rush to settle. We did ultimately settle for a really good number, but it's because the judge was really pushing that plaintiff to do some work.
Yeah, and I think that really flows into the next slide, which is, okay, you might get a demand letter, you might get a lawsuit, but there's some sort of taking stock of position of where you are, and I think Dianna, Heidi, maybe you talk about like what are the steps that you would normally take if a client comes to you and says, I've got one of these. What questions do you ask them, but then also what do you sort of suggest are some of the first steps that they can take?
Sure. So, if you get a demand letter or you get a complaint, the first thing you want to do is notify your insurance carrier. You don't want to get coverage disclaimed for late notice, usually under EPL, sometimes D&O policies, but now is a good time to speak to your broker, make sure you have this coverage in place, understand what your policy covers in terms of remediation, and also see what your deductible is, because sometimes our clients are surprised to find out how high their deductible is for these types of cases. You're also going to want to retain counsel, not only to discuss your defense, which we'll talk about in the next slide, but also to help maintain privilege when you secure a vendor, to remedy the website. And also, you also want to run a scan of your website, because we've had cases where we've gotten all these allegations that the website is not compliant, and we've run a scan and it's 95% compliant. And that has been great leverage in getting a much lower settlement for our clients. So that's what you want to do once you initially get the suit.
Yeah, I just wanted to add to.
Yeah, and
sorry,
I just wanted to add that.
Yeah, go.
Some of our clients weren't interested in settling cases right away, but one of our carriers would have an incentive and would actually give them a discount off of their deductible if they would settle the case, and sometimes they could even get remediation from settling early. So that was some of the motivation that helped us get some of these cases resolved, at least in the early days. And it seems to be continuing today as well. And I'm sorry, Jason, I think I cut you off.
No, I just wanted to say from a practical point of view, when we talk to clients that might get a demand letter or a lawsuit, and we suggest that they probably at least have an early conversation with an ADA experienced lawyer like Dianna or Heidi, is because these are brought by or sent by a very small group of plaintiff firms. So the experience of how those plaintiff firms want to work, what their process is, some send demand letters, but if you don't respond to the demand letters, they don't end up going to ADA lawsuits. So sort of understanding the sort of landscape can instantly give you an advantage early on, and that's why I think it's very important to reach out to someone who's got that sort of ADA experience and knows the players and what they're trying to achieve and how they're trying to achieve it. And then maybe we can go to the next slide where maybe Dan, you can give us a little bit more on sort of where you think what people can do to reduce their lawsuit risk.
Sure.
Sure.
Heidi was going to, yeah, go ahead, Heidi.
Okay, so like Dianna was saying, we've had cases in Florida that have, required discovery and things like that. So you want to look at the circuit where you are, because what's going on in Florida is going to be different from what's going on in California or New York. So you definitely want to see where you are and, what the trend is in terms of these suits, where you're located. Like I said before, you want to look at your website. You want to run a scan, see if these claims are actually true. And you always want to constantly be making sure your website is up to date and accessible. That you have vendors that are constantly monitoring your website. You may want an indemnification provision in your agreement with your vendors in case they're not monitoring it and you get hit with one of these suits. And we also just briefly wanted to mention IRS code for section 44. We don't give tax advice. You obviously need to consult with your financial advisor to confirm whether or not you're eligible, but there is some authority to support that this section of the IRS code can provide a tax credit for remediation to make your website accessible. So Dianna, if there's anything you want to add?
Too. Yeah, they liken that to the ADA barrier cases, the architectural barrier cases that were exploding in the early 2000s, where there has been authority to allow that to be a tax deduction, the remediation costs. So a lot of our plaintiffs' attorneys are arguing that they are entitled to more money because it's really going to help our client in the end because they're going to be able to deduct all this expense. Like Heidi said, we don't give tax advice. We do recommend you speak with your accountant about that, but that is an option that's being thrown out there.
Yeah, to me, there's one item there that you talked about, which I think is also very important for most retailers. Most retailers didn't build their website themselves. They probably paid a company to do it, or they still pay a company to maintain it. So the first thing I would do is, even if you don't have a lawsuit, is to be calling your vendor of your website and apps and making sure that your contracts include the remediation of accessibility. You're going to get a lawsuit for a website you probably paid for, and of course that's going to be your first call after you get that lawsuit. But being proactive right now and making sure that contracts that you're signing for websites or apps, making sure that you're putting the requirement into those contracts, I think is going to give you a lot of protection later on. Even if you get a lawsuit, at least you've got a partner that you can hold responsible for doing remediation and stuff. So. And then maybe we just, I think we have a slide here, I think, which you're going to talk about, sort of how you can, some of the options for sort of defending yourself. So go back one, I think, Bethany, which is the legal defenses. If you could cover that down, and Heidi.
Sure. So again, you're going to want to discuss with your attorney whether or not you want to fight this case or you want to just enter into an early settlement. I'm just going to briefly discuss some of the defenses we've seen in some cases lately. I just wanted to point out that there's a trend for the courts to find that providing a phone number and an email address on the website is not sufficient to be ADA compliant. And the reasoning behind that is because you're putting the burden on a visually impaired person to either wait for a response or call during business hours, which sighted individuals are not going to have to do. So that's not a defense in these cases. I just wanted to briefly discuss Diaz versus Kroger, in which a mootness argument was used, basically saying, well, we fixed the website, this lawsuit should be thrown out. And that case was successful, and we've seen other cases that have not been successful with this defense because the defendant submitted an affidavit from its product design manager, who's someone who's intimately knowledgeable of the website, saying that everything was completely 100% remediated to the applicable WCAG standards at the time, that they've investigated it, and they're continuing to monitor it. So, we've seen other cases where maybe an executive at the company who had no knowledge of what was actually on the website submitted an affidavit, and the courts have said, well, how do I know what you're saying is accurate? So, it's got to be very specific with these things in terms of the defense. And that case was also thrown out because Kroger's an Ohio company, has its headquarters in Ohio, and the plaintiff was a resident of Bronx, New York, and Kroger doesn't deliver its groceries to the Bronx. So the court basically said, we don't have the power to hail you into court here in New York. And I know we had a couple of universities on our list. So I just wanted to point out that this defense may not work for universities that are not in the same state. as a plaintiff. So, you know, the courts are finding that if you use a website to advertise your university in connection with like a college fair in that state, and there's an interactive tool such as a tuition calculator, that the court will likely find that you can be sued in that state where the plaintiff is. And I just briefly wanted to touch on Mendez versus Apple, in which there was no injury. So if the plaintiff, you know, alleges that your website is inaccessible, but they didn't actually suffer an injury. So in this case, for example, the plaintiff said, well, I couldn't access making an appointment to have a device fixed, but she didn't allege that she actually owned an Apple product. So where was the injury there? So those are a couple of defenses we've seen. And Dianna, do you want to add anything before I just briefly touch on the settlement agreements and consent decrees?
I just did the Kroger one. I was really excited about because that was also out of New York, and I thought it was just a terrific decision that just kind of really started putting the brakes on some of these lawsuits. And the mootness argument, I really hope to be expanded upon. And one thing that to keep in mind is that when you do have a website and you're monitoring it, make sure that you have in your settlement agreements, if you're sued, that you're also going to continue monitoring in the future. And we'll talk about that later, but I just kind of wanted to fit it in here too as well. But that's all I wanted to say.
Right, so I just wanted to throw in some key points that you want to put into settlement agreements and then this consent decree trend as well. So, you know, a few key things we're seeing in settlement agreements is, like Dianna said, a commitment to making the website accessible now and continuing to monitoring it, ongoing monitoring. You know, you may want to put a notice and cure provision in there so that the plaintiff has to let you know that there's an issue before they bring it back to court. And another thing we're seeing is making sure that you are not liable for third-party advertisements and links on your website to the extent that they're not providing WCAG compliant content. So, and again, if you're renewing contracts with people who advertise on your website or who have links on your website, you want to make sure any new contracts or renewal contracts, you want to make sure that they're committed to providing WCAG compliant content on the website. And
yeah, an example of that would be there's an example of what Heidi was just saying is there was a lawsuit in Florida involving a grocery store that had hyperlinks to its local farmers, and the local farmers' websites were not WCAG compliant. So it is important that you double check your vendor agreements to see, you know, what's happening there.
Right, and just a note about consent decrees. So this is a trend we're seeing now as well. So your settlement agreement, it's going to be confidential, you know, the amount, everything like that. But people are filing consent decrees with the court, which basically the court is ordering you to make the remediations on the website, and they'll maintain jurisdiction for X amount of time. You know, we see between 12 and 36 months typically. But this basically lets other potential plaintiffs know, hey, look, a court's ordered me to remediate this, and this is the only relief you're going to get if you bring a lawsuit against me is to have the website remediated. So it's sort of a deterrent to other plaintiffs bringing lawsuits. So that might be a way to prevent suits from multiple plaintiffs against you, although these are relatively new, so the courts are unclear as to whether these are actually binding, and the circuits are not in agreement either. So they're a line of defense, but you also want to make sure your website is compliant and continuing to monitor it to make it compliant.
And then finally, Dianna and Heidi, maybe you could give us, some may have heard of, you know, the potential holy grail of new legislation around that, around ADA with the Online Act. Maybe you could give us a sort of insight of what you think might be the future, you know, in the next 12, 24 months, what your views are, whether the future is going to change at all.
Sure. So there's a pending bill with the House. It's the Online Accessibility Act. It's actually bipartisan. So there is some hope here that we're going to get some real guidance out of legislation. So it basically does have a notice and cure provision in it, which, you know, they put the company on notice that the website's not compliant, and they get a chance to fix it before you go straight to a lawsuit, which I think would be very helpful, because that would curb some of these plaintiffs, these serial plaintiffs out there. I think that if, you know, if Biden is successful, which looks like it's going to happen, we're going to return to the DOJ, where they were not ready to put in the guidance. They had all the steps in place. I don't know why they didn't finish it off, but the guidance now is looking to be WCAG 2.1, possibly 2.2, because that's on the horizon. So I think that that's probably going to be happening. I do anticipate that we'll get some guidance pretty soon, whether it's through legislation or through the Department of Justice. And we certainly have it through some case law out there as well. So I don't think arguing that the ADA does not apply to websites is going to has any muster at all anymore in anyone's mind. So.
Yeah, I mean, I think the reality of the sort of volume of the world is that your website and app should be made accessible, because it should be made accessible. Plus, pretty much every circuit court believes that in some way it is a place of accommodation, and you need to make sure people can access it. I think there's still lots of debate about what does accessibility mean? What does it mean that people with disabilities can use the website equally as everybody else? And that's sort of like where, you know, a lot of people get stuck. But, you know, what I would like to offer is sort of like an idea of what I think you should do immediately and short term. And that's the next slide, I think, Bethany. You know, taking everything you've heard today, you know, in paraphrasing, is there's lots of plaintiffs and plaintiff lawyers out there going through a certain process to find the sites that they want to sue. That process involves a blind person. That process involves going after the websites and apps. That process involves, in some cases, you know, scanning the website with these sort of free scan tools to find the low-hanging issues. So the things you could do immediately right now that would make your site a lot easier to use and give you confidence that someone who is blind could use it, firstly, is to decide what are your sort of exposed public-facing websites and apps. Get someone who is blind from either a blind community, from one of the advocacy groups like Miami Federation for the Blind, the Miami Lighthouse, the American Foundation for the Blind. Also, we have resources which are available for hire. Have blind people try to use your site. If they achieve all the sort of top user goals that typical users can do, you're in great shape. You've got someone that you can document has actually achieved it. So if you get a lawsuit, you're going to be giving someone like Dianna and Heidi good documentation to help them negotiate or try and get the actual case dismissed. If the blind person can't do it, you've instantly got prioritization. You know what issues they find, what they're having really problems with. That you can then give to your development, your third-party company, and say, we really need to solve these because this is real users having problems. Secondly, do that scan, fix those easy issues. Most of those issues that a scan's going to find are easy to fix. Fix those issues, make sure that if someone scans your site, you achieve a good score, and write up an accessibility statement that talks about how you are committed to make sure the website's accessible, make it easy for people to connect with you if they have issues. I mean, Dianna and Heidi could maybe talk about the fact that the ADA is a civil rights act. It's about a company making sure they don't discriminate. They don't have a process in place that discriminates. So essentially making sure people know that you have a process in place which is aimed at being inclusive and not discriminating. Dianna and Heidi, I don't know if you had anything to add to that. Dianna and Heidi, are you still there?
I'm sorry. Yes, Jason. I'm was actually looking at some of the Q&As there, so I
Okay,
didn't
no,
hear
good.
the
Yeah, 'cause
exact question. I'm sorry.
That's what we're going to do next. So that's a good use of time. That's a good distraction.
I'm sorry. I
No,
don't know if
that's
Heidi wants to jump in. I didn't hear.
I was actually doing the same thing.
that's
sorry.
okay.
What were you asking about the accessibility statement?
Yeah, I was just in. People have argued like, oh, you shouldn't put any statement up, or you should put a statement up. My philosophy is that if you're doing something, you actually are doing something, even if you haven't achieved it yet. You should make some statements around what you believe in, what you're trying to achieve, and make it very easy for people to contact you if they've got a problem. But I didn't know what your thoughts are on that.
I absolutely agree with that 100%. I think it does help a lot in the negotiation process as well.
Yeah, and then just to close out this sort of what should you be planning, especially in 2021, and I think Dianna and Heidi have really sort of told you what you need to do. If you go to the final slide, you really need to start, planning for accessibility to be part of new builds, revamps. You need to probably set a priority of, what sort of, again, what issues you should be solving on the current website. You should be, working with a company that can give you a really detailed, quick list of things that you should be fixing straight away. You need to be working, with your third-party vendors who are building sites to make sure that it's in part of the contract. Make sure that they know that they should be fixing and verifying what they're building for you to certain standards. And then, same to what Dianna and Heidi said, you need a process for maintenance. In just the same way as you would, test for other things, when you do releases, you should be adding web accessibility as part of that go, no-go type testing. And that's really that's a summary and sort of close up the end. And I think what we want to do, move into sort of a Q&A. And as we've got Dianna and Heidi, I'd encourage us to make sure that we're focused on questions, which we think Dianna and Heidi can give us some color to. Bethany, did you want to take it back over, or did you want maybe Dianna and Heidi to pick out questions?
Yeah, I can start us off, and if the speakers want to, read them aloud, we can do that as well. We have one question here. When we work with clients on, that I think is really good. When we work with clients on accessibility, we are careful to cover as much of the WCAG as we can and confirm that users of different abilities are able to complete the most important user journeys. So not necessarily all of them, but the biggest ones. However, there may still be some accessibility issues that may be present. With ADA law not specifying WCAG as the standard, what do you think is the tipping point for triggering an accessibility lawsuit?
Heidi, you want to take that?
Sure. So I think there's a couple of things here. And I think another issue is that, plaintiffs are suing under WCAG 2.1 now. 2.2 is about to come out, but there's been no clear guidance from the courts, whether it's 2.0 or 2.1, that's the standard. But I think, if you have some of the big issues like we were discussing earlier that are missing, like alt text, missing hyperlinks, inability to access forms, things like that. And the plaintiff's attorneys that do run a scan, sometimes they'll just run a few pages and say there's so many problems here, let's go ahead and file this suit. And this is also an issue that the Online Accessibility Act was seeking to address. I think it was going to hold that, there's substantial compliance with the WCAG standards, that it would be, there wouldn't be penalties. But again, we don't really know what that means. And I think this goes into another question I saw, that the Architectural and Transportation Barriers Compliance Board, or the Access Board, is supposed to issue guidelines on that, standards and definitions of substantial compliance and alternative means of access and things like that. But it could take up to 2 years to get the final regulations, even if that bill is passed. So, long story short, I think if you see some of the big issues that we were talking about earlier, like alt text and missing hyperlinks and broken links and things like that, if the plaintiff sees that, they're going to try to file the suit or send a demand letter. Diana, did you want to add anything?
Yeah, yes. And I think that the more compliant, for lack of a better word, the website is, the better we are able to negotiate a very, very favorable settlement number. So we've had some really low cases when our clients have been, vastly compliant, and it's been really, really nice to defend those cases. And as far as like the Online Accessibility Act, I don't know if the Department of Justice is going to have the manpower to be able to address a lot of these issues. So I do think it's not going to eliminate the lawsuits. I think that we still are going to be stuck with some lawsuits, even if that act does pass. But it will alleviate some things, I hope. And the widget question, I don't think that's something I know about. I don't know if Jason or Heidi knows that.
I'm sorry.
We haven't seen those.
Maybe Bethany, you could pull out that question. What was the question?
Yeah, so we have a question asking to address the use of widgets and why or why not they are not effective for deterring these type of lawsuits. Usableness data that we pulled out, we found, I can't remember the exact number now, but a lot of the lawsuits as of mid-year 2020 had, some of them had accessibility widgets installed on the website. So they're asking why those widgets are not effective at deterring lawsuits.
This is Jason. I'd go back to that slide I talked about. How does a plaintiff work? A plaintiff scans your website and it's scanning code for missing elements, which Heidi talked about, missing alt tags, missing form labels, missing headers, these types of things. And widgets don't fix those. So widgets are sort of an alternative way to try to get around a site. So if you've got a widget on your site and you run the same scan, the number of issues that came up before you put the widget on and after you put the widget on is pretty much the same. So that's not going to deter a plaintiff from listing your website in a lawsuit. The more practical reason is also that most of the widgets sort of look really good to people like us who actually don't use assistive technology, because they sort of add this sort of cool like assistive technology layer onto a website. And to someone like us that don't use assistive technology, we might think, well, that's pretty cool. Look how it's added this added benefit layer. But assistive users already have their tool. They have a screen reader, they have a Zoom text. What they need is the code to comply with WCAG. If the code complies with WCAG, then their screen reader works. So what widgets do is sort of a little bit of a trick to people who don't know anything about accessibility and don't know anything about how blind people use a website. It looks good to people who can see. It doesn't sound good to someone who uses a screen reader. So, these are the reasons why, I think last week there was 100 lawsuits. I'll go back to that. 10 of them were against companies who already had widgets on their site. So just that anecdotal evidence means that widgets do not stop lawsuits.
And we have a good recording video that we did with our head user tester where he's actually on a website that uses a widget, and you can see and hear his experience, which is you can hear the widget actually battling it out with his screen reader. They're talking over each other. So I can send that out as a link following this webinar too, because it is a good resource to have. And I see another question kind of around that same idea.
And I had another question I saw is what fines are associated with these lawsuits, low versus high. So when the Department of Justice was involved, they would issue fines depending on like the number of frequencies that the party was brought before the Department of Justice. So those fees and penalties were roughly between $75,000 and $150,000. And then California's Unruh Act has statutory damages. So the minimum recovery is $4,000. And forgot to mention damages with the ADA. The plaintiff does not, there's no provision for a plaintiff to receive monetary damages from an ADA lawsuit. However, most of the attorneys are getting their attorney's fees, and those are ranging from various amounts depending on the nature of the website. So roughly the plaintiffs will say that they're only going to get $500, but you know, in likelihood they're getting a little bit more. We're not real sure, but how those are breaking out. So sometimes the plaintiff will say give $500 to the plaintiff and $5,000 to the attorney, and settlement. That's sometimes how those things work. And sometimes they can be as high as $35,000. That's the way that used to be.
Okay. So we do have some more questions coming in, but we are at 1 o'clock. So what I can do is I want to encourage everyone to put your question into the Q&A, and I'll be able to pull a report of those questions, and we can actually reach out to you with the answers if we didn't have time to get to your question today, but I want to be respectful of everyone's time. So thank you everyone who joined today, and thank you to our speakers, Dianna, Heidi, and Jason. We so appreciate it. We will be sending out a link to the recording and the slides next week. And with that, the webinar is now ended. Thank you.
Thank you.